Welcome to this video on the 2026 legal revolution in New Zealand. We will explore how modern courts are balancing time, legal tactics, and the pursuit of truth. The landscape of legal strategy has shifted. While the past focused on tactical delays and hiding evidence, the 2026 update emphasizes proportional justice, early disclosure, and focusing on the truth. Key updates to the High Court rules include a mandate for proportionality in costs and time, a duty for lawyers to cooperate in good faith, and a requirement for initial disclosure of adverse documents. In Wang versus Body Corporate, we see a clear example of the new approach. The court rejected an attempt to use a simple appeal on costs as a vehicle for new, unrelated allegations. Because that application was disproportionate and late, the court dismissed it and issued a cost penalty for wasting judicial resources, reinforcing the new procedural focus. Understanding time is crucial. The Limitation Act 2010 sets expiration dates for civil claims, including a primary 6-year period, a late knowledge grace period, and an absolute 15-year long stop. In the case of Liu versus Wu, a contract for $1.2 million was challenged on the basis that it was signed under duress and was essentially illegal blackmail. The defense attempted to use the Limitation Act as a shield, arguing the blackmail claim was out of time. They sought to block the court from examining the substantive truth. The Supreme Court ultimately rejected that defense. The ruling established that when pleadings are based on the same factual core, the court will prioritize substantive justice over rigid technicality. However, employment law is a different arena. Under the Employment Relations Act, the clock is absolute, and disputes must be resolved promptly for the sake of businesses and workers. It is a tale of two clocks. While general civil law offers high flexibility for late claims, employment law enforces a strict 90-day limit for personal grievances, with almost zero flexibility. Exceptions in employment law are rare, limited to cases of extreme trauma, representative error, or severe health issues. These represent the very narrow window for relief. This landscape shows why different arenas require different strategies. Employment law remains strictly focused on procedural compliance, whereas the High Court now pivots towards substantive truth. In summary, front-foot your case with early disclosure in civil matters, expect courts to prioritize truth over procedural shields, and always respect the absolute deadlines in employment disputes.